To Spectacular Chicago. I'm Jim Balzer, and tonight I'll be your host. Today's show will deal with consumer reports based on an outpouring of suggestions from viewership on topics that they'd like to discuss. Everybody's had issues with car repairs and other things, relating to things you buy in the stores, and they wanted to talk about it, and I took to heart their suggestions, and tonight we'll have a few things to cover, including some high-profile court cases that are pending in Cook County at the moment. But first, I'd like to talk about Lay's potato chips, a recent box truck ad on screen, please. So it says, "Stay golden." Rod Blagojevich must be concerned that Jay's is muscling in on his phrase that he coined, as I recall, effing golden. A copyright infringement? You decide. Off screen. Next, I'm going to discuss body shop. We've all had a fender bender from time to time, take our car to the body shop, and we have to rely upon these folks to do the proper work on our vehicles, because if they don't, the repair won't last, and we're not satisfied customers, and we'll tell our friends. So that situation has occurred. Dayton Auto Builders, Rebuilders, 60th place in Chicago. Can we go on screen with an image of Dayton? Okay. Next, we'll go on screen with an image of a Lexus LS400 in the paint booth at Dayton Auto Body. Now, Dayton performed auto repairs and painting on this Lexus and used such poor materials, craftsmanship, and refinishing on this rear quarter panel that the repair failed, as evidenced by peeling and blistering paint. Notice the remainder of the 25-year-old paint is in like new condition. So next we'll go on screen with the result of their repair on screen with, now this is the rear quarter panel on this vehicle. The rest of the paint is Bristol in perfect condition, yet the repair that they performed, and contacting two body shops that actually look at it, they used improper paint, improper finishing, improper everything, and as you can see, the repair has failed miserably. You can see it's faded, it's blistering, the clear coat is separating, and it's going to cost over $4,000 to repair the image. Let's go on screen next with Scott Kahn. Kahn sounds like a villain from Star Trek. I visited with Mr. Kahn and I brought him the vehicle. Now, Mr. Kahn happens to be the new, call him service manager at Dayton. And he comes out and he looks at the vehicle and he says, "God, whoever did this repair did a SHITTY job." I said, "Really?" He says, "Yeah, look at this. These are wrong materials. Look at this clear coat is failing. The paint was done wrong. They didn't all these things he said." So let's go off screen with Mr. Kahn. And guess what? I said, "Well, Scott, guess who did the work?" He says, "Who?" "You guys." He says, "Oh, well, we didn't do that." I said, "Yes, you did." I said, "This is before your time." I said, "It just failed." So I said, "The rest of this paint is 25 years old, perfect condition. This repair, look at it, a couple years." Let's go on screen with their receptionist. Now this young lady, when I visited the shop, she's sitting there. She couldn't be distracted from watching her Trump rally and couldn't be bothered to attend to my business, but she was a little bit snippy. And I don't mean to be unchivalrous, but gosh, I wish I had brought grapes. The owner was provided with a copy of a draft lawsuit. Let's go off screen. So after that, the owner of the business was provided with a copy of a demand vis-a-vis a draft lawsuit. Hey, take responsibility for your bad work. You think they did? No, didn't respond. We're not responsible. Yes, you are. There's a picture of the car in your shop. You did the work. We can't find the receipts. We can't find anything. It's done by your shop. This guy did it. Okay, let's go on to the next thing. Next, we're going to discuss a class action lawsuit filed against Ford over failures of their EcoBoost engines. But first, a comment from Ford CEO Jim Farley, who says he's sick and tired of building boring cars. CEO Farley said, "We're getting out of the boring car business and into the iconic vehicle business." Words to live by. Ford, Ford, Ford. Okay, so today's Consumer Report on Ford happens to be a 250-page class action lawsuit for failures of their engine. So I interfaced with a Mr. Kurska, who purchased a 2017 Ford Edge with a 2.0 liter engine from Roche Ford. I think that's in Elmhurst, which experienced engine failure due to design defects at 107,000 miles. Now this car, on information, was babied, well maintained, not hot rodded. His wife, I don't know, she's 50 something, drives it, goes to church, does a few things, but she's not a hot rodder. Local, suburban, mild driving. So can we put on screen image of Roche Ford? Okay, so I visited Roche Ford with Mr. Kurska because I wanted to get this interview down and have good facts, and visited with Mr. Freddie Seng, general manager at this dealership. And Mr. Kurska presented to Mr. Seng, hey, I had to spend almost $10,000 to repair my vehicle for this defective engine. Let's go off screen. Mr. Seng said, well, he didn't know anything about the Ford class action lawsuit, despite the fact that there's been tons of technical service bulletins by Ford. Mr. Kurska takes his vehicle to the Ford dealer. They knew immediately, another Ford dealer, they knew immediately what was wrong with it. And but yet Mr. Seng denies and disavows any knowledge of a class action lawsuit. So I sent it to him, and I sent it to his, I think it's his boss, Dave Roche. And I gave Dave an opportunity to respond before doing this show. No, he's got better plans. Not interested. But I'm looking at the technical service bulletin, and 2.0 EcoBoost coolant and cylinders, white exhaust smoke, and a illuminated check engine light. 22-2229. And it has 2015 through 2018 Edge, which is his vehicle, and then a myriad of other vehicles. And the claim document, this is the technical service bulletin. It says report a problem. The solution is engine block, replace. Replace the engine block. And that's, well, Mr. Kurska spent $8,201.81 because Ford wouldn't take care of him. Ford wouldn't take care of him. And we have a copy here of, and I'm going to go through some of the allegations from the lawsuit itself. And just looking off camera here, it's Miller is the lead plaintiff in this versus Ford Motor Company. And it's case number 220CV 1796, consolidated with numbers 221CV00417. And then there's a 221CV00468, and this is in the United States District Court, Eastern District of California. So that's, I think it sounds like Los Angeles area. And I'm looking at the table of contents. There's 28 lead plaintiffs from almost every state in the union. And there's voluminous table of contents outlining all of the failures. In the table of contents, what's glaring under the factual allegations, and I believe I should read it verbatim, Ford knew that the EcoBoost engines in the subject vehicle were defective since at least 2012. But it continued to sell these engines anyway. And you have other things here that over the past decade, Ford has issued multiple ineffective recalls for issues relating to coolant leaks and overheating in EcoBoost engines. In other words, the coolant was getting into the cylinders. Ford knew of the engine defects from its pre-release design, manufacturing, engineering, and testing data. Ford knew about the engine defects from voluminous internal data on repairs and consumer reports. So in other words, Freddie doesn't know anything about it. Nobody finds that credible, including myself. So Ford was well aware of the engine defect from class member complaints collected by NHTSA, including, if anybody doesn't know what that is, it's National Highway Traffic Safety Administration. And then Ford created a customer service program for the defect, but they're not dealing with it. They're making you, Ford owners who have these defective engines, pay for the repairs. So I'm going through table of contents on this thing. It's a 250-page document. I'm not going to bore you and spare you the listening to me read a 250-page document. There's not enough time in the hour we have. But all of these causes of action, are for the various states. So you have to outline it by state and you break it down. So in this class action lawsuit, Ford is brought into it, but the individual dealers are not, because they have a mandatory arbitration clause. All of us, when you buy a vehicle from a dealer and there's a problem and you want to sue them, you can't just take them to court. You have to go through mandatory arbitration, and that's weighted against the consumer, because guess who lobbied for the mandatory arbitration? You guessed it, Ford in this instance, and the other car manufacturers. They don't want us getting our day in court. They don't want us taking them to court. They don't want a jury. They want mandatory arbitration where, perhaps some of those judges that they helped get appointed to the bench are going to be deciding their case. So they got a lot of sway. So the table of contents continues with the other causes of action, including 248 pages. So 51 causes of action for all the lead plaintiffs and the violations of their various state consumer acts that exist in those areas where they have plaintiffs. So I'm going to read from the document the nature of the action. But it says the vehicles at issue in the action include Ford vehicles equipped with 1.5 liter, 1.6 liter, or 2.0 liter EcoBoost engines. The EcoBoost engines. These vehicles are 2013 to 2019 Ford, and they've got a range of models. But if you just focus on EcoBoost and that size engine, you may be affected. So the EcoBoost engines in each of the class vehicles are substantially the same from an engineering standpoint, notwithstanding their various sizes. The EcoBoost engines in the class vehicles contain the same relevant components made of the same materials. In other words, layman's terms, it's the same junk. The EcoBoost engines in the class vehicles have a critical defect that causes engine coolant, which is vital to the safety and functionality of the engine, to leak into the engine's cylinders. That's referred to as the engine defect. The lack of coolant created by the leaks causes overheating and can, even at low mileage, result in cylinder head cracking, and in some instances can cause total engine failure and engine fires. So presence of coolant within the cylinders of the engine alone can cause corrosion, oil dilution, and contamination and engine failure. So if you get coolant into the engine and the oil, you can ruin the engine fairly quickly. So Ford has failed to, according to this, Ford has failed to provide an effective solution to consumers who purchased or leased these class vehicles. Ford has not satisfactorily or effectively addressed the source of the defect for those consumers, including those whose vehicles remain in warranty. So in Mr. Kurska's case, his vehicle has 107,000 miles, so he's out of the warranty even though we got the extended warranty. You don't expect an engine to blow up and fail at 107,000 miles. A vehicle today, Toyota, let's say, you get 300,000, 350,000 miles out of a car that's properly maintained today. However, perhaps Ford doesn't see it that way. You know, you buy a new vehicle. So let's go on to the next page here, and I'll continue to read. So Ford merely applies superficial stopgap Band-Aid remedies such as installing coolant level sensors. I guess you want to know when the coolant's going down. You don't have to know why. This sensor alerts consumers when their coolant has been depleted. Well, makes sense, so that they can replenish it. It does not, however, prevent further future coolant depletions. You're not supposed to have to keep adding coolant. It's not good for the environment either, I might add. So in some instances, Ford just replaces certain parts other than the defective engine block, thereby failing to address the root cause of the engine defect. Now, I don't have statistics on how many of these engines are out there, but it's considerable. It's a common engine for Ford, and it's over a large range and series of vehicles over many years now. So it continues, these half measures force consumers to return repeatedly for service and to continue driving a vehicle at risk of future damage to the engine and components, engine failure, and engine fires. Consumers whose EcoBoost engines overheat or fail when the vehicle is out of warranty must pay out-of-pocket expenses for necessary repairs, and again, they may have to return for repeated service if Ford does not replace the defective engine. And with a non-defective engine block, these repairs, including a full engine replacement, can cost thousands of dollars. So I have a receipt from Mr. Kurska. It's not quite 10,000, but it's, you know, with everything else involved, it's about that, 10,000. Not everybody can afford $10,000 to repair their car. You need it for work. Your engine fails on a car like that, you don't have a car. You lose your job. You get evicted. All kinds of bad things can happen to you when you don't have a reliable vehicle, notwithstanding the safety issues. Your car breaks down in the middle of you're trying to make a left turn and you're turning and the engine fails and conks out, and you know, you get hit broadsided or somebody's pissed off, they start shooting at you, I don't know. But anyway, let's go on. So it says further, consumers whose engines overheat or fail when the vehicle is out of warranty must pay those out-of-pocket expenses. So tough luck, out of warranty. So the engine defect interferes with plaintiffs' and class members' safe, comfortable, and expected use of their vehicles. Okay? If Ford does not replace the defective engine with a non-defective engine block, those repairs, including a full engine replacement, can cost thousands of dollars. This is true. The engine defect interferes with plaintiffs' and poses a risk created by the engine failures, as I've just described. And then it says, they talk about discovery. We'll show that before selling or leasing the class vehicles, Ford knew about the engine defect through sources including pre-production testing, pre-production design, failure mode analysis, pre-release evaluation and testing, repair and warranty data, replacement part sales data, high failure rates and analysis and response. So everything is online. Every part number, everything, they know in this computer age what's going on. And that's even before the artificial intelligence is going to be kicking in. They know, they've got data, they see the failures ramping up, they see the dealers, hey, we got a problem here. For those dealers that admit that there's a problem, unlike Roche Ford. So it's also talking about, early consumer complaints made directly to Ford and posted on public online vehicle owners forums. So there's forums. You and I, we own a Ford, we want to be on a forum. We talk about that. And then, so the Ford dealers are kind of agents in a sense for Ford. I would imagine they're talking, they're buying stuff from them. They might say, hey, the stuff you're shipping us is having problems. So, yet despite this knowledge, the complaint continues, Ford failed to disclose and actively concealed the engine defects from class members and the public. And Ford has continued to market and advertise the class vehicles as safe, comfortable, and of high quality. Okay. So they go on, and then I'm almost done reading. As a result of Ford's alleged misconduct, plaintiffs and class members were harmed and suffered actual damages, including that the class vehicles contain the engine defects. I'm going to get some help here reading this fine print. Okay? Then they go on to say that Ford has not provided a permanent no-cost remedy for this defect in a reasonable amount of time. Furthermore, plaintiff and class members have incurred and will continue to incur out-of-pocket and unreimbursed costs and expenses relating to the engine defect. So it goes on here to list the parties, and that's 250 pages worth. But it talks about violations as relates to the Illinois plaintiffs. It talks about violation of the Illinois Consumer Fraud and Deceptive Businesses Practice Act. And these lawyers, this isn't their first rodeo, and they did a very, very fine job of outlining and defining what that is. And so, in summary, and I'll read from their report, the purpose of the Illinois Consumer Fraud and Deceptive Business Practice Act is to enjoin trade practices which confuse or deceive consumers. The Illinois CFA, as they call it, Unfair or Deceptive Act or practices, including but not limited to the use of employment or of any deception, fraud, false pretense, yada, yada, yada. So you can't misrepresent a product, and if you know that there's a problem, you have a duty and an obligation to disclose it. It doesn't appear that this particular dealer, even though they say they knew about it, which nobody believes, disclosed it to this consumer before they purchased the vehicle. Otherwise, they wouldn't have purchased it, right? So Ford participated and engaged in deceptive business or trade practices prohibited by the Illinois CFA by failing to disclose and actively concealing that the class vehicles contained the engine defects, by marketing their class vehicles as safe and of high quality, and by presenting themselves as a reputable manufacturer that valued safety and stood behind its vehicles after they were sold. They're not doing that. They're making everybody file a lawsuit. So the difference between, I'd say, the American manufacturers and the foreign is the Americans won't take responsibility, where the foreign manufacturers, they know better. They pull this. They may not be able to, export their cars to our country. So they take, I would say, better and proper care. Let's go on. So Ford knew that the class vehicles and their engines suffer from an inherent defect, were defectively designed and manufactured, and were not suitable for their intended use. Okay, so it continues on with, this Illinois Protection Act in this lawsuit, and they ad volume. They just regurgitate all of the statute, and it talks about the false representations, but I think you all get it. And then there's one aspect of this that I'd like to read as well. Defendants' violations present a continuing risk to Illinois plaintiffs and the Illinois subclass members as well as to the general public. Well, what does that mean? Vehicle stalls, stops in heavy traffic and speed. Somebody else hits them. They cause an accident. Somebody gets killed, injured, perhaps. So defendants' violations, unlawful acts and practices, they assert, affect the public interest. So they say as approximate and direct cause of Ford's unfair and deceptive trade practices, Illinois plaintiffs who purchased or leased vehicles suffered an ascertainable loss and financial harm, about 10 grand. Yet they're not dealing with it. So these plaintiffs also provided notice to Ford about their claims, and nothing happened. And next there is breach of express warranty. Now that deals with when you have, typically Ford has, in this case, I believe on this vehicle, they have a 60,000 mile warranty, and it's supposed to cover the engine, all internal lubricated parts, cylinder block, cylinder heads, blah, blah, blah. And yet those that have the warranty apparently aren't being covered. And then there's for certified pre-owned vehicles, which would affect Mr. Kurska, Ford offers an additional limited warranty for 12 months or 12,000 miles, so it would be 72,000. So he's out of that warranty period, yet he bought a vehicle, had he known and had he been informed, and Ford knew it, would not have purchased that vehicle. Why purchase anything where you're going to have to replace the engine? The engine's going to fail because it was improperly designed. That doesn't make good sense. Okay, so it states here further in this document, and I'm going to get back to it. They state here that the dealers, they talk about the dealers a little bit. They were not intended to be the ultimate consumers of their vehicles and have no rights under the warranty agreement provided by the class vehicles. So the warranty agreements were designed for all and the intended benefits of the consumer only, as they say here. So these contracts give the dealership the right to sell Ford and Lincoln vehicles, but yet they don't want to take responsibility. So, they sit there and stonewall. No, we're not going to fix it. Yeah. They tell Mr. Kurska, join the class action lawsuit, sir. And then they tell me, and they point to him when I'm there, you shouldn't have brought this guy, meaning me. People who know me don't talk to me that way anymore and expect not to be called out on it, Freddie. So let's go back to the agency relationship. That establishes privity for the purposes of the breach of the implied warranty claims. So privity, it's privity is not required where plaintiffs are intended third-party beneficiaries of a defendant's implied warranty. So, and the contracts between Ford and its authorized dealers. So there's a contract between Ford and its dealers directing them, and there's two-way communication. They're expected to do that. They buy parts from them. The regional manager visits, hey, how are things going? Hey, by the way, we've got this problem. We keep getting these cars coming in. But Roche Ford, well, we don't know anything about it. We didn't hear anything about it. Who told you that? Okay, so in this prayer for relief, at the very end of this I have page 248 here. Could you believe it? At the end of this document, there's a prayer for relief, and it's basically saying they're having to force Ford to court, and they want a declaration that the EcoBoost engines in the class vehicles are defective. That means once you get a federal, that affects everybody. They're going to have to pony up. A declaration that Ford is financially responsible for notifying all class members about the defective nature of the class vehicles. An order enjoining Ford from further deception, distribution, sales, and lease practice with respect to the class vehicles. I wonder if that includes the dealers. You know, God, those are such trustworthy people. An order requiring Ford to permanently repair class vehicles with a reasonable time period, no cost to class members, so they no longer possess the engine defect. Okay, so that continues on, and then there's a demand for a jury trial. A jury trial. Imagine that. So, remember, if all the dealers are getting sued, got to go to mandatory arbitration. Here you get a jury, which helps promote the cause. So the next thing I'd like to go on screen with, let me collect my documents here, is get rid of some of these papers. We're going to go to, there's an old advertisement by Ford that comes to mind, and I'd like to play it for you. Let's hear it.
Have you driven a Ford? Then you don't know what you're missing. Have you driven a Ford? When was the last time you had a car like this to drive? Talking about the kind of car that brings the road alive. Remember when? How long has it been? Put the key in, put the top down, let it go. You got that feeling again. Have you driven a Ford? Look at her. Then you don't know what you're missing. Have you driven a Ford? Driven Ford lately?
Okay, Ford. Do you see any of those vehicles on the road today? No, of course not. But I'd like to ask this gentleman if he's driven a Ford lately. On screen with Mr. Justice Kavanaugh. Justice Kavanaugh, people want to know, have you driven a Ford lately? Well, I guess the corporate mother doesn't love after all. Can we go off screen? Toyota, in contrast, takes their brand image seriously and has pride in their reputation. So, in contrast, Toyota issued the voluntary safety recall in May 2024 of this year, identifying machine debris as a culprit failure of their 2022-2023 V6 twin turbo engines. And apparently debris got in the manufacturing, machining process, and it gets into the bearings and it ruins the engine over time. You get rod knocking and things. So here's what Toyota is doing, in contrast to Ford. Toyota is conducting a safety recall involving certain model year 2022, 2023 Toyota Tundra and Lexus, and it's affecting approximately 102 100,000 of these engines. But they're doing it. And they've acknowledged, the first step to solving a problem is acknowledging you have a problem, not jerk you around. They've acknowledged the issue. We have an issue. We're going to take care of it. Our reputation is at stake. Our customers and our consumers, their safety, they're taking care of it. And over 100,000 engines, and let's say these are $5,000 long blocks. I'm not even factoring in labor. Say 5,000 each times 100,000. I think my math, I hope it's right, $500 million. That's a lot of money. But when your reputation is at stake, you take and you spend whatever is necessary to take and spend to solve the problem. Okay, so I'd comment, in Chicago, I believe all the police vehicles are Fords. Why, Mayor Johnson, are we buying anything from Ford? Should put them in Toyotas. You got a problem? They're going to warranty it. I don't know if those Ford vehicles are EcoBoost or not for the squads, the cruisers, but I imagine based on the history that I've just read here, there could be issues. So I think the city of Chicago should do something. I know we have a Ford plant. It's not the employee's fault. Maybe the union should step up and say, hey, Ford, we don't want to build vehicles that are going to fail, that cause a safety, health issue to drivers, the public. Step up, union. Okay, next we're going to talk about Craftsman tools. If anybody's ever bought a Craftsman tool, so this came in, somebody said, hey, I bought this Craftsman tool set, and I contacted the dealer who sold it to me. So there's a little switch here that you toggle to change the direction of the ratchet. And this one, the lever broke off, and the consumer attempted to get satisfaction. They said, well, read us the number off the part. Oh, that's not one that was made at this plant, it was made at another, therefore we can't warranty it. You have to contact Craftsman directly. Well, wait a minute, you're a dealer. You sell well, yeah, but it's a different Craftsman. Well, it's Craftsman. So I actually took the time to figure out how that was going to work, contacted the warranty, 2 hours on the phone, and didn't get through to anybody. Nobody called back, nobody got back. 2 hours, so what happens is the consumer gives up. So anybody who's considering buying Craftsman tools may want to inquire what their options. But back in the day, you brought the tool in, hey, this is broken, failed, you'd get a new tool in a heartbeat. They wouldn't ask any question, they just give it to you, send it back to Craftsman. Okay. Let's talk about chiropractors. That's another, those that have had a back adjustment or need back adjustment, sometimes people use chiropractors. Can we go on screen with Dr. Robert Butt? This man was just successfully sued in the Law Division in Cook County for performing an adjustment on a Chicago policeman, Elazar Maldonado, resulting in the patient suffering a stroke. So he had a dissected arteries that are run through a couple of your vertebrae in your neck that were dissected, I guess. And while he's there, he's throwing up and he's not feeling well, he can't walk, and they tell him, you must be suffering from food poisoning. They don't call an ambulance, they don't do anything. Man goes home, he can't stand, he's bouncing off the walls. And so the case that was filed at trial, the jury found the defendant doctor liable. And I sat in on this, and this gentleman is telling the jury, I became a chiropractor because I was injured as an iron worker. And I wanted to, do something for everybody else, similarly situated, I suppose. And as it turns out on his website, it says, I became a chiropractor because I suffered a high school injury. Let's go off screen with Dr. Butt. So, the law firm that's representing the defendant is Swanson Martin Bell, LLP, purportedly a top shelf law firm. And, you know, they did their best. That's what lawyers do. But no matter, due to many factors, the jury awarded this police officer almost $4 million. He's trying to collect. Now the defendant doesn't want to pay and is employing a myriad of, I'll call them schemes, to delay, obfuscate, and avoid payment. Interestingly, defendant's law firm is part of their, I'll call it, my opinion, shimmy-shammy, does not want plaintiff's counsel, her name is Adina Weiss Ortiz, to be able to talk about the fact that they beat this top shelf law firm. And they were, you know, they got trounced. Another trial matter that I've been following that I'd like to discuss is the wrongful death lawsuit filed on behalf of the estate of Rona Rozo and her minor child Leah, who's the beneficiary. And it's entitled, it's 2023L064001, and it's Nefer Rozo, which is her sister, versus Pershile Country Hotel, doing business as Holiday Inn, Countryside, Maritza Arez, Ana Cosio, Rosa Gomez, Rincon Family Services, Inc., Dr. Greg Gendel, Advent Healthcare, Dr. Aftab Khan, Jackson Park Hospital Foundation, Dr. Jorge Ferrar, Sinai Health System, Adventist LaGrange Memorial Hospital, Mount Sinai Hospital Medical Center of Chicago, Mount Sinai Hospital Medical Center of Chicago again, and then the city of Chicago is mentioned along with Dr. Javed Iqbal. Let's go on screen with Rona Rozo. Now, Rona is a Venezuelan migrant, and as some of you may recall in the news, and it made the news, she was found deceased with a noose around her neck in the hallway or the stairwell of the Holiday Inn. And what this is about is she visited several of these doctors in these hospitals and was under the care of these various agencies when she arrived in Chicago, including the city, I might add, who says, oh, we have nothing to do about it, yet they're spending millions and millions of dollars, considerable money on caring for these migrants, and they're failing on the healthcare level. That's certain. You've heard about that in the news at some of the shelters. But anyway, I'm sitting there listening to a motion call, and this is in Judge Maureen O'Hannon's courtroom. She's a good judge. She's sharp. I think a word to describe her would be sleek. And on October 8th, counsel for plaintiff was presenting her motion for leave to amend the wrongful death complaint on an alternative theory, because all these attorneys are saying, oh, we're not responsible, oh, this is wrong. That's the job of the defense lawyers, is to confuse and obfuscate the court so that they get out of it. But the plaintiff's counsel is doing a pretty good job, and she does her homework, it appears, and that's my opinion. And anyway, upon query from the court as to the plaintiff's alternative theory on the case and the nexus for the city of Chicago as a defendant, I observed all counsels that weren't immediately in front of the court, but all these others, these top shelf lawyers, literally snicking in their shirt sleeves in open court during the hearing. Off screen. So here's a list of the attorneys listed for the defendants. Stuart Rappaport, Shannon Holbrook, Scott Irvin, Lisa DeLeon, Ann Nelson, Stephen Glockner, Laura Jeanette. Now, I don't know, I can't sit there and in that courtroom know them. They don't have name tags, but I imagine all of them, or substantially all of them, were in that courtroom. But I'm listing all of them because they're laughing. So who are they laughing at? Then, you ask. Are they laughing at plaintiff's counsel? It would immediately appear so, but here's who they're really laughing at. Let's show an image of Leah Rozzo, please. This is Leah Rozzo, and she's a 7-year-old who lost her mother in the case. And as I alluded earlier, certain defendants in the case did not take proper care nor adequate time to understand, diagnose, prescribe necessary medication to her mother, Rona Rozzo, who suffered from paranoia schizophrenia. And she had medication. She was fine, completely functioning adult, but she didn't get the medication. They gave her gummy bears and placebos, and, you know, so she didn't get the medication she needed, and these doctors were, I'll use the word I think's fair, quacks. And so this resulted in the death of her mother, Rona. So she's unmedicated. She has an episode. She's in the hallway. They leave a rope out, a long rope. This unmedicated person looks at the rope. I don't know what she was thinking. I can't get in somebody's mind who has lost their mind at that point to empathize what's going on in their head. But she's found hung, and there's nothing so harrowing. If we can go off screen. One of the defendants, Dr. Greg Jindal, is avoiding service of summons process. You have to serve somebody with the paperwork in order to hail them into court. It appears he skipped town. They're trying to find him, and they're visiting his family, the sheriffs and the process servers. We don't know. Family doesn't know. Well, he's a doctor. We don't know where he is. He must be practicing somewhere. I can't find him. One would think he'd want to clear his name by appearing in court, but instead he remains elusive. So I'm going to talk about next some Chicago events. So, as many of you may or may not know, Mayor Johnson kept a campaign promise. Imagine a politician keeping a campaign promise and deactivated and did not renew the ShotSpotter contract. So the ShotSpotter listening devices are being deactivated, and reports are the system is being removed. Yet, I'm informed that the Chicago Police were FOIA, Freedom of Information Act, was propounded on the Chicago Police Department. We want to know where all these, as Mayor Johnson refers to them, walkie-talkies are located. They're listening devices, and as I sat in on a federal trial, I could sit there and hear voices coming off the ShotSpotter system. So it's wasn't just picking up gunshots. It could actually listen to voices. I heard it at the trial in federal court on another matter. I'm not going to get into it here. I'm just telling you that that's what I heard. What the public really wants, and this may escape the alderman and the mayor even is a system that can catch the dog owners who do not see fit to clean up after their pets who defecate on our city sidewalks. Now, that's not optimum for those tango dancers, I tell you this. So, I know, sound thinking, as we're called, can buy a vowel. So, we have shot spotter, S-H-O-T, spotter. I propose we go S-H-I-T, spotter. We can buy a vowel. Thank you, Vanna. Now, that is sound thinking. We're going to talk about Jewel Osco. If anybody's visited recently, I elected to go visit the Jewel Osco on Roosevelt Road, and it's right near State, probably closer to Wabash. And you know, I don't go to Jewel much. It's hard to sit there and walk down the aisles and look at shelf after shelf of what I considered unhealthy food. One of my first gigs was in a health food store before anybody knew what they were. I mean, tofu, fresh juices, everything that you couldn't find anywhere else in the entire metro Chicago area was at this store, and it was great. So I have a little history and background, and I can look at stuff and I know if it's healthy or not. Anyway, so the processed food, the rows of sugar water, I'll call it, and notwithstanding the fact that that is a very unsafe location. You know, you read online, news, people are getting shot, they're getting, attacked. It's just a very unsafe area, but yet Jewel doesn't do anything about it. It appears they have high turnover rate of employees. But here's something that kind of codifies the problem. So what you're looking at here are two Jewel receipts that were handed to me after I ordered. They have really good fried chicken there, I'll say that, and grilled. And I said, "What's this?" Where's my chicken? That I just, oh, we changed the rules. You now have to take this to the checkout. So I got a basket of stuff. I go to the checkout, pay for the chicken, show us you paid for the chicken, and come back and we'll give you. I said, well, what happens if you run out of chicken? Well, there's nothing about that we can do. I said, well, I'm not going to buy it. So I said, well, why do you have this? They said, the chicken's getting stolen. So it's either so good or the area is so dangerous that everybody's stealing the chicken. Imagine that. So they're going to put the screws on the paying consumers. So I tell you this, Jewel Osco, if they're stealing the chicken, they're stealing a heck of a lot of other things other than chicken. So, I couldn't help but talk about Jewel because frankly, I think nobody should shop until they get their act together there. Just briefly, I was going to talk a little bit about the dress code in Chicago. It costs a lot of money to look poor these days. And it seems like, I don't know, I try to take a little pride and, polish my shoes and comb my hair, brush my teeth, and wear some, make an effort. Yet, I see the ugliest clothes. They don't match, there's no rhyme or reason, and it's like a contest to the bottom. So the richest country in the world, and, we're dressing like ragamuffins. So finally, I'd like to take the remainder of my time and conclude in solidarity, I hope I'm saying that right, to Ukraine. There's an image some years ago that was featured in Chicago Magazine featuring Mila Ugrin from Ukraine, and the image depicts, she had at one time a red scarf behind her. She's on her sailboat in the middle of Lake Michigan with the city backdrop. So we took the red scarf she had and we superimposed the Ukrainian flag. Before we post the image, I'm going to thank you for your time and listening, and I'll part ways by posting Mila for the remainder of the time. And thank you.